purpose of my session today is really to talk about the law governing costs orders for unreasonable conduct in the ET. And in doing that, there are three things that I primarily propose to cover. Firstly, we're going to look at threshold. What are the grounds for seeking an award of costs, and how do we meet those grounds? The second is to look at the caution that needs to be applied to any application for costs when you are considering the position of litigants in person, or in particular forms of cases like discrimination or perhaps whistleblowing. And with that second objective in mind, we're going to take a look at some more recent guidance this year from the Employment Appeal Tribunal in how to approach these applications. In our own practice, we may well be seeing perhaps a slight increase in the number of costs orders that are being awarded in the ET. But the key takeaway, without giving anything away about what you're going to hear in terms of the recent authorities, is that it is very much business as usual as far as more recent guidance has indicated. In short, the EAT has reaffirmed the principle that costs remain the exception rather than the rule. Now, that will be reassuring for claimant lawyers among us perhaps, but perhaps also a source of frustration for those of you that largely represent respondents. And that's particularly given the context of the current climate that we find ourselves in. Latest figures from the MOJ suggest that last year, Employment Tribunal claims went up by 21%, both single and multiple claims. That is placing inevitable pressure on the Employment Tribunal, as we will all be experiencing. The frustrations with the lack of judicial capacity, cases being pulled from the list at the last minute, and cases being listed much further on. So I just recently had a case listed in Watford in September 2027 for a fairly straightforward 5-day hearing. And I'm sure many of you will be experiencing very much the same thing. But just as the number of claims are increasing, so are the number of unrepresented claimants. And again, latest figures from the MOJ suggest that on average, around a third of claimants in the Employment Tribunal are litigants in person. What the data also shows is that when a claimant is unrepresented, they are much less likely to succeed in their claims at a final hearing. I think on average around 15, certainly below 20% of those claims actually succeed. So there's a real balance to be struck here in between discouraging hopeless claims on the one hand, but ensuring access to justice, to ensure David, as far as possible, is on an equal footing with Goliath. And that's particularly important in cases, as I say, involving litigants in person, or in more complex matters, such as discrimination or whistleblowing. So going back to the threshold, that first thing that we need to cover, the threshold for costs awards. That's set out in Rule 74.2 of the Employment Tribunal rules. Firstly, under A, there has to be vexatious, abusive, disruptive, or otherwise unreasonable conduct in the bringing or the conducting of proceedings or part of it. Secondly, under B, a costs application may succeed if it's found that the claim or defence had no reasonable prospect of success. And then finally, if there's been a late postponement of a claim within 7 days of a hearing. Under Rule 74.2b, the question of whether a claim or defence has no reasonable prospects of success involves a purely objective assessment of the merits of the claim. It's very straightforward, and the authority for that proposition is Vaughan and London Borough of Lewisham. However, a person who brings a claim or defence that has no reasonable prospects of success could, in certain circumstances, be said to be acting otherwise unreasonably within the meaning of Rule 74.2a. Now, that assessment requires an analysis of the party's knowledge of the merits of the claim or defence. What did they know, or what they ought to have known if they'd gone about the matter sensibly? So a slightly different standard and test. If you're considering bringing an application for costs on the basis of unreasonable conduct, the tribunal will adopt a three-stage process. Firstly, it will make findings of fact about the conduct in question and must explain with reasons which parts of that conduct met the threshold. If that threshold is met, the tribunal then goes on to consider whether to exercise its discretion to award costs. It needs to take into account all of the circumstances before it, including wisely the ability to pay. It's not mandatory for the tribunal to consider a party's ability to pay, but it's certainly wise to do so. And only when stages 1 and 2 are exhausted should it then go on to consider the amount of costs. So let's go back to those thresholds and dealing first with unreasonable conduct under Rule 74.2a. What types of behaviour could pass those thresholds? Now, vexatious conduct generally covers circumstances where perhaps unmeritorious claims are pursued for some underlying goal. And there are two examples of that, Bin and Scadam, and then Keska. Keska is a case, for example, where the tribunal found that there was virtually nothing to support the allegation of race discrimination, and the claimant's motivation was resentment and spite. So that's the type of conduct that would ordinarily fall under vexatious conduct. In terms of abusive or disruptive conduct, abusive has really its ordinary meaning. It can cover things like threatening emails made perhaps in pre-hearing correspondence. It can include aggressive cross-examination, and so on and so forth. Whereas disruptive conduct tends to be conduct that interferes with the orderly conduct of proceedings, perhaps non-compliance with court orders, or unduly lengthy or aggressive cross-examination. We dealt with a case earlier this year in which a costs award was made, where the conduct really straddled a lot of the elements of Rule 74.2a. That was a case where we had an unrepresented claimant who'd made 26 separate allegations of race discrimination, all of which were ultimately dismissed by the tribunal. In terms of his conduct, in both his pleadings and his cross-examination, he made allegations that were completely unsubstantiated, groundless allegations, for example, that one of the respondents' witnesses was engaged in modern-day slavery. He also made what the tribunal described in their judgment as an unexplained suggestion of fraud during the course of his submission, something that he hadn't mentioned before then in evidence or in any witness statement. And one of the things that certainly irked the tribunal is that despite there being a bundle close to 2,000 pages, and having already set out his pleadings, he failed to produce a witness statement which addressed any of those allegations. I think from memory, it was a witness statement of about 5 lines or something like that. And that was despite him being given repeated warnings, both from the respondent solicitors and from the tribunal, about providing a full witness statement, even despite the fact that the respondent had to apply for an unless order. And so in that case, which again straddled a lot of those different descriptors, the tribunal awarded costs on the basis of unreasonable conduct of £20,000. In terms of otherwise unreasonable conduct, that's a very broad spectrum of conduct that can be covered. It can include things like dishonesty. It can include, as we've discussed, presenting or pursuing a claim or defence that has no reasonable prospect of success. It can include the unreasonable refusal of a settlement offer or a refusal to engage in settlement discussions. And it can also include the unreasonable withdrawal of a claim at the 11th hour after the point that the parties have already incurred the costs of representation. So I'm going to look at each of those types of conduct in turn. Firstly, dishonesty. Just because a party or witness lies, it doesn't automatically mean that they are acting unreasonably for the purposes of unreasonable conduct and costs. What is important here is the context of that lie and the nature, gravity, and effect of it in determining unreasonableness. And that principle is illustrated very well in the two contrasting cases of Kapoor and also Daleside Nursing Home. Now, in Kapoor, the Employment Tribunal concluded that their finding of dishonesty in relation to the claimant automatically meant unreasonableness, and they awarded costs. And on appeal to the EAT, the EAT said that was wrong. You have to consider all of the circumstances and the extent to which that lie made a material impact on the proceedings. And that point of material impact was considered in Daleside Nursing Home. In that case, the claimant had made 3 allegations of race discrimination. 2 of those allegations were not explicit acts. They were allegations surrounding things like rates of pay, where any of those allegations of discrimination arose by way of inference from what would have otherwise been relatively neutral acts. The 3rd allegation, however, was an explicit and deeply unpleasant allegation of racist abuse. And the tribunal found that the claimant had lied on that particular point. When this went to the EAT concluded that it was perverse of the tribunal at first instance not to award costs in relation to that central lie, because it was an allegation which, if it had been accepted, would have influenced the way in which the tribunal looked at those otherwise neutral acts in determining whether they were acts of discrimination. So it was a lie that was material and would have had a material impact on the proceedings. So Daleside really emphasises that in considering costs, the material impact is key and is a crucial consideration. Turning to hopeless cases, we've already looked at this in that in determining otherwise unreasonable conduct under Rule 74(2)A, you need to look at what the party knows or what they ought to have known if they'd gone about the matter sensibly. But when the tribunal is assessing this point, it's important to bear in mind 2 important issues. The first is that hindsight is a wonderful thing. We've all got first-hand knowledge of this. The way in which our cases look on paper at the start of a case, before horns are locked, often looks very different to the case that we find ourselves with after the battle is over and after the dust has settled. And the tribunal must be alive to the fact that it's important not to engage in some post-match analysis to a certain extent in assessing a party's conduct, bearing that in mind. And then secondly, assessing what a party knew or ought to have known, it's important that litigants in person aren't held to the same standards as those who are professionally represented. And the tribunal must bear in mind the particular challenges faced by those litigants in person, particularly in cases involving discrimination. That's not to say that litigants in person are immune from costs orders, because we can see from the alternative limb under Rule 74(2)B If a case has no reasonable prospects of success, that's an objective assessment. And claimants who've misunderstood matters could well find themselves passing the threshold for an unreasonable costs order. But where the fact of their lack of representation comes into relevance in those types of scenarios is when we move on to the second element of the process, which is the exercise of discretion. A case may well have no reasonable prospects of success, but if there is a litigant in person struggling to deal with a very complex discrimination claim, they may well be given the benefit of the doubt in terms of any costs award. And in several cases, including Sachs and Fitzroy Robinson, the Employment Appeal Tribunal has been very alive to this particular point. And a more recent example of that is in the case of Madu and Loughborough College from earlier this year. That was a case where the Employment Appeal Tribunal upheld an appeal against a £20,000 costs order, which was made against a claimant who'd brought a claim of race discrimination arising from a job application. Now, the claimant in that case had originally represented himself at the start of proceedings, but had later obtained legal representation as the case went on. The tribunal at first instance awarded costs against him for two reasons. One, that they said he should have realised even from the outset of proceedings, even before he had representation, that his case had no reasonable prospects of success. And that secondly, that he must have received that advice after he had instructed solicitors. Now, at the EAT, the respondent conceded that on that latter point, the tribunal had erred, that it wasn't appropriate to make assumptions about privileged legal advice. But they asked the EAT to uphold the decision in any event because it had passed that objective test under Rule 74(2)(b). But Judge James Taylor, sitting at the EAT, said no. The error alone had undermined the entire judgment in that case. And he also stated that the Employment Tribunal had erred in concluding that the claimant should have appreciated from the outset that the claim had no reasonable prospect of success. He said that the tribunal had had no regard to the difficulties faced by this unrepresented claimant. And notably from the judgment, what he said is, in many discrimination complaints, the outcome turns on the Employment Tribunal deciding whether the claimant's treatment was materially influenced by the relevant protected characteristics. Much may turn on the performance of the person alleged to have discriminated against the claimant under cross-examination, and it can be difficult for a claimant, especially if acting in person, to form a clear view of the likely prospects of success prior to the hearing itself. So Madu really is a salient reminder to tribunals not to be too ready to dish out costs awards in discrimination claims, particularly those involving litigants in person. But I just want to focus on the case of Leeks, which is another Judge Taylor case. That concerned two claims of disability discrimination arising from a recruitment exercise carried out by the respondents. There were various delays in the claimant not progressing the case properly, which led to two separate applications by the respondent over the course of 4 years, seeking to strike out the claim on the basis that the claimant had not progressed the claim properly. Now, at the hearing of the second application, 4 years post-issue of claim, the claimant had applied for her costs on the basis that the respondent had failed to engage in judicial mediation. The tribunal struck out the claim itself and also dismissed her application for costs. But crucially, it refused the costs application on the basis that it said a refusal to engage in judicial mediation could never result in an order for costs. The claimant appealed on both the dismissal of the claim and the dismissal of the application, but it's the costs issue that I want to just focus on. While she was successful at the Employment Appeal Tribunal on that point, and the matter was remitted back to the tribunal for redetermination, that was primarily because of the tribunal's original decision that a refusal to engage in judicial mediation was an absolute bar. And again, Judge Taylor said that that's simply not right. The test depends on all of the circumstances, including the fact that judicial mediation was voluntary and protecting the sanctity of any without prejudice discussions. The EAT did, however, emphasise in allowing the appeal that it would only be exceptional circumstances that costs would be awarded in these types of scenarios, and they described the claimant's application as optimistic. In terms of withdrawal of claims, this is an area that could, in certain circumstances, amount to otherwise unreasonable conduct under Rule 74(2)A, and Macpherson's a good example of that. Here we had a case that involved a very late withdrawal of a claim in circumstances where prior to that withdrawal, the claimant had previously successfully applied for a postponement of the final hearing. And in doing that, they had provided misleading medical evidence. Now, the tribunal awarded costs of £90,000 in that case, but by the time this got up to the Court of Appeal, whilst the Court of Appeal said that costs were justified, they drew us back to that point of material impact. They only made a costs order that would reflect the costs that were incurred up to after the point where the postponement was applied for, so after the point that the misleading medical information was provided, because what they said was prior to that point there was no evidence of any unreasonable conduct. So the final case I'm going to look at this afternoon relates to the exercise of the tribunal's discretion to award costs and a party's ability to pay. Now, Rule 82 provides that in determining whether to make a costs order and the amount of that order, the tribunal may take into account a party's ability to pay. It doesn't have to, but it would be advisable certainly to do that. And in looking at ability to pay, they can take into account capital and income, but particular care does need to be adopted where, for example, a capital asset such as the family home would need to be sold in order to satisfy a costs order. But a really good example of a robust approach by both the tribunal and the EAT to substantial costs awards is the case of Willis and GWB Harthills. The claimant in that case was a solicitor by profession who brought claims in the Employment Tribunal. At first instance, after the dismissal of his claims, he was ordered to pay the respondent's costs of £210,000, on any analysis, a very high costs award indeed. And the tribunal had made that order after finding that the claimant hadn't told the truth. They did attempted to mislead the tribunal. They described his deception as extreme and said that it was particularly egregious for a party who was a solicitor. And in considering his ability to pay, they took into account his half share of the family home and his projected unpaid profit share from the LLP. Now, the claimant appealed to the Employment Appeal Tribunal, and he said that actually what the tribunal should have looked at and failed to take into account was the impact of this order on his wife and his family. He said it would be unlikely that he'd be able to pay those costs without selling the family home, and as he was suffering from stage 4 cancer and his wife was his primary carer, in actual fact, the effect of that order wouldn't fall on his shoulders, it would fall on his wife and his children. But the Employment Appeal Tribunal had no hesitation whatsoever in upholding the tribunal's decision on costs. They found that it was entitled to adopt a reasonably rosy assessment of the claimant's likely future circumstances and a broad brush approach to the assessment of his means. And a motivating factor in that was the scepticism in relation to his evidence and the evidence of his previous dishonesty. So perhaps some comfort for respondent solicitors. A key takeaway from this is that tribunals may well be emboldened by this decision to consider making costs orders, particularly in cases involving very serious dishonesty. Finally, in terms of a few tips, first thing I would say is if you are considering making an application for costs on the basis of unreasonable conduct, first thing to consider is to ensure that you gather evidence of that conduct, both from an early stage and throughout the proceedings. Note evidence of threatening emails or failures to abide by the tribunal's orders and so on, and the steps that you have taken as your client's representative that has incurred further costs. For example, if you've had to chase up or send repeated emails on a particular point, if a person has failed to, for example, exchange documents. You can consider cost warnings in obviously in appropriate circumstances. The effect of that, again, in appropriate cases, would be to put the other party on notice that their conduct is considered either to be unreasonable or that you view that their claim is having no reasonable prospect of success, which would certainly strengthen any future application that you would make. Secondly, remember that a lost case doesn't automatically justify a costs order. It's the party's conduct that's important, and the tribunal needs to be assisted to understand which threshold has been crossed and why, and we need to explain and support that contention with evidence about what it is about the party's conduct that is, for example, vexatious or abusive or unreasonable. And we also need to map that conduct into impact. How has that increased our costs, the length of the hearing, the time spent on correspondence and so on? And then the final point really is if you believe that one or more of the thresholds have been met, we also need to consider whether we should advise our clients to make a costs application at all, or if we do advise them to make an application, whether that should be on a summary or detailed assessment basis. And really central to that decision will be your assessment of the other side's ability to pay and your prospects of success on the application. If a party is of relatively modest means, doesn't own property, for example, there'll be little benefit to your client pursuing an application certainly on a detailed assessment basis, since the cost of that would most likely outweigh any costs you'd be likely to recover in return. And then finally, remember that a costs application must be made certainly within 28 days of the date that the judgment was sent to the parties.